Good morning, one and all present here. I, Vagish Mishra, take the opportunity to welcome you all and everyone here this morning. It is a great honor and respect that I extend a warm invitation to our distinguished dignitaries, the Honorable Mr. Justice Ujjal Bhuyan, Judge of the Honorable Supreme Court of India, and the esteemed chief guest of today's occasion, the Honorable Justice Devendra Kumar Upadhye, the Chief Justice of Bombay High Court, our revered guest of honor, the Honorable Justice Mr. Makrand Karnik, the Judge of the Bombay High Court, and the Honorable Justice Madhav Jamdar, the Judge of the Bombay High Court, the Honorable Mr. Justice Rajesh Patil, Judge of the Bombay High Court, and the Honorable Dr. Biren Shroff, the Advocate General of the State of Maharashtra. We kindly request to you all to come on the stage and grace this occasion with your esteemed presence. Now, I would request the host of the event, Mr. Ravi Pulyani, the Managing Director of the Bharat Law House, to felicitate the chief guest of today's event, the Honorable Mr. Justice Ujjal Bhuyan, Judge of the Honorable Supreme Court of India.
May I call my brother Mahesh Pulyani also with me? We both are together in the business. And Sanjay, could you please join us? Sanjay Kumar. A very close family friend and more like a younger brother, Sanjay. Thank you very much for being with us from Allahabad, especially for this occasion.
We are also glad to inform that our chief guest is accompanied by his family. It gives us immense pleasure to welcome Mrs. Sangamitra Das Bhuyan. I would request Advocate Mrs. Meena Tripathi to felicitate ma'am. I would request Advocate Mr. Arun Tripathi to felicitate our guest of honor, the Honorable Mr. Justice Devendra Kumar Upadhye, the Chief Justice of Bombay High Court. Now I would request Advocate S.N. Raj to felicitate our special invitee, Honorable Mr. Justice Makrand Karnik, Judge of Bombay High Court. Now I would request Mr. Amit Gupta, advocate, to felicitate our special invitee, Mr. Justice Madhav Jamdar, Judge of the Bombay High Court. I would now request Advocate Vineet Naik to felicitate our special invitee, Honorable Justice Rajesh Patil, the Judge of Bombay High Court. I would now request Advocate Upasana Pandey to felicitate our special invitee, Honorable Dr. Biren Shroff, Advocate General of State of Maharashtra. Ladies and gentlemen, we are deeply honored to welcome you all to this momentous occasion, the launch of the book Treatise on PMLA, Law and Practice. This book is not just a compilation of law and regulations, but a comprehensive guide that sheds light on the intricacies of the PMLA 2002. The PMLA 2002 is a significant piece of legislation aimed at combating money laundering in India. It represents our nation's commitment to maintaining financial stability and integrity and transparency. However, the complexities of the Act and its implications are often challenging to navigate. This book aims to bridge the gap, providing clarity and insights into the Act's various aspects. The book is authored by Mr. Akhilesh Dubey, Advocate and Solicitor, UK, who has meticulously researched and compiled this book, ensuring it both comprehensive and accessible. It serves as a valuable resource for legal professionals, students, and anyone interested in understanding the PMLA 2002. As we unveil this book today, we hope it will serve as a beacon, guiding those who seek to understand and navigate the complexities of the PMLA 2002. I remember a shlok in Sanskrit, Vidya Param Balam, meaning knowledge is supreme power. We believe that knowledge is the key to empowerment, and this book is a testament to that belief. Thank you all for being a part of this significant event. Your presence here today underscores the importance of continuous learning and the pursuit of knowledge in our ever-evolving legal landscape. Let's celebrate the launch of this remarkable book, a testament to the power of knowledge and the importance of understanding the law governs us. Thank you. I request the honorable dignitaries on the dais to release the book. May I kindly invite Mr. Amit Gupta, the advocate from Delhi, practicing in Supreme Court of India and Delhi High Court, to grace the stage and make us glance through this event. With this distinguished leadership, we eagerly look forward to his stewardship of this occasion to make the occasion more memorable. Mr. Amit Gupta.
Good morning to one and all. It's my absolute pleasure to stand before you on this significant occasion. We are joined today by distinguished members of the bar and the bench, whose wisdom and insight will undoubtedly enrich our afternoon. I'm truly delighted to be a part of this enlightened gathering. Our first guest is Honorable Mr. Justice Rajesh Patil. Honorable Justice Rajesh Patil graduated from Mumbai University with Bachelor of Commerce degree and secured a LLB from Mumbai University. He has embarked on his journey of legal practice in 1996 and was associated with senior counsel Mr. Abhayankar for many years. Justice Patil has expertise in various fields of law and has represented many public sector undertakings. Justice Patil was elevated as an additional judge of Bombay High Court on 19 July 2002. Justice Patil's steadfast dedication to the pursuit of justice is truly admirable. Known for his tireless efforts, often working late into the night, he embodies the very essence of commitment to cause of justice. I request Justice Patil to say a few words to grace this occasion.
I'm fortunate today to share the dais with Honorable the Supreme Court Judge, Justice Bhuyan, Honorable the Chief Justice of Bombay High Court, Justice Devendra Upadhye, my brother Judge, Justice Makrand Karnik, my brother Judge, Justice Madhav Jamdar, the Advocate General of Maharashtra, Mr. and all you advocates and the staff who is here. First of all, let's tell me one thing. When I heard about this book, one thing came to my mind. How does one find a time to write a book? You all will agree with me. Now, when I had a look at this book and the volume of this book and the topic of it, probably the PMLA is the right topic on which the author has chosen to write a book. I just asked him, how can you write a book, such a big book? So came an answer. Pandemic was bad. Pandemic was very bad for everybody. Some people, they used it in the right way. And I believe the author used it in the rightest way one can think about. So congratulations, Mr. Dubey, for writing this book. Then I thought, what is that effort which requires to write a book? And came into my mind an event of my chamber when I was still with Mr. Abhyankar. Amongst all of us, 7 of us, and most of you know we are 7 of us. I said to him, sir, why don't you write a book? So he looked at me, okay. So what do you think should be the topic? Sir, can we write on rent tax? Means we are day in, day out doing it. I said, no. We said, sir, then what? Hindu law. So I said, Hindu law, okay. Then, Rajesh, don't you think that it requires a lot of research and work? Yes, of course it requires. Start. Start. I think I have done a wrong thing by telling him to write a book. But anyways, we all 7 of us, we started it. We did it for 2 days. And that time, the admission board and the final hearing board. But till that time, the final hearing board was every day taken up. So after 2 days, we said, let us give it up. I think we should. And then, of course, you all know that the unfortunate thing happened and he fell ill. So that thing remained as it is. Anyways, Mr. Dubey, you have done a great job by writing this book. And I just had a cursory look because it becomes actually too difficult to actually get into a book and to read it in the whole sense. But yes, of course, I will do it. But I was looking into one chapter and the chapter was Appendix 63. Now, Appendix 63, unlike many other books which I have just referred to, says about frequently asked questions. Now, when you look at this frequently asked question, and if you're looking into the topic of PMLA, many things crop up in your mind. What is this PMLA? Why you hear about PMLA so much time? So when you look at that chapter, that appendix, and frequently asked question, maybe many of your questions gets an answer. So actually you did a very good job by putting up that chapter, which rarely we find in a book. So once again, congratulations and all the best, Mr. Dubey. Thank you very much.
Thank you, Justice Patil. We hope we are privileged to have a book by you very soon. Our next guest is Honorable Mr. Justice Madhav Jamdar. Justice Jamdar started his legal career in 1991. Apart from obtaining his LLB degree in 91, Justice Jamdar obtained a diploma in industrial analytical chemistry in 1988. In fact, it's one thing which my author would share with Justice Jamdar, since he's also a chemistry graduate. Justice Jamdar practiced extensively on the appellate as well as the original side in the Bombay High Court and appeared in a large number of civil, criminal, and constitutional matters. He appeared in a number of PILs concerning important issues such as deaths of sewage workers, environment, pollution of rivers, felling of trees, allotment of incorrect marks in CET for admission to medical colleges, charging of exorbitant fees by colleges, etc. As a lawyer, Justice Jamdar has consistently been a beacon of hope for the underprivileged, lending his voice to their cause and aiding them in their pursuit of justice. His unwavering support and advocacy for the less fortunate is truly commendable and serves as an inspiration to all. Justice Jamdar was elevated as an additional judge of the Bombay High Court on 7 January 2020 and has passed several notable judgments since then. May I kindly invite Justice Jamdar to share his insights and enrich this event with his esteemed words. Sir.
Good morning to one and all. The esteemed chief guest of today's event, the Honorable Sri Justice Ujjal Bhuyan, Judge of the Supreme Court of India. I had the privilege of sitting with Justice Bhuyan on the bench at the Bombay High Court for a few months, and I learned a lot from his lordship. The Honorable Chief Justice, Shri Devendra Kumar Upadhye, as the guardian judge of Ratnagiri, I had the honor and privilege of hosting the Honorable the Chief Justice at Ratnagiri for his lordship's first public event at a district place in Maharashtra as a Chief Justice of the Bombay High Court. And I believe today I am here because of Chief Justice, because he assigned me bail matters in January, and that was the reason why I am here. Honorable Sri Justice Makrand Karnik, Judge of the Bombay High Court and my dear friend since more than 30 years. But I have to say good thing about him because he also knows many things about me and I also know many things about him. No, the Chief Justice has got a clue now. And another close friend, Honorable Sri Justice Rajesh Patil, Judge of the Bombay High Court. I think after 1 year, we will be again here for that release of commentary on Hindu law, because section 6 is evolving. The Advocate General. I thought that my task will be very simple because Advocate General speaks very well. But today, he has been silenced or he and Mr. Akhilesh Dubey, advocate and solicitor, who has authored the book which has been released today. And all the esteemed guests present here. At the outset, I congratulate Mr. Dubey for writing a comprehensive and well-researched commentary on a very important and significant law, that is PMLA. I am confident that the commentary will be useful to the students of law. All of you know that students of law, this term means students of law colleges, advocates, senior advocates, and judges. The commentary by Mr. Dubey will help everyone who is concerned with the implementation of the PMLA. Now, I don't know why I have been told to speak for 15 minutes when other speakers have hardly spoken for. I think the task is given to me to completely bore you people so that. But just see this money laundering. Black's Law Dictionary defines money laundering as the act of transferring illegally obtained money through legitimate people or accounts so that its original source cannot be traced. It is being realized world over that money laundering poses a serious threat not only to the financial systems of countries but also to their integrity and sovereignty. The PMLA came into force in the year 2005 to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and for matters connected therewith or incidental thereto. For the money laundering, what is the most important aspect is proceeds of crime. Proceeds of crime is defined as any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or relatable to the scheduled offense. There are many aspects of PMLA. However, I will focus on only one aspect because that aspect is assigned to me by Honorable Chief Justice. That aspect is concerning bail under PMLA. Parameters of granting bail under Section 439 of CRPC are well established. The court has to take into consideration various factors while granting bail. Some of them are as follows: the nature and gravity of the circumstances in which the offense is committed, the position and status of the accused with reference to the victim and the witness, the likelihood of the accused fleeing from justice, tampering with evidence, influencing witnesses, the history of the case as well as of its investigation. However, Section 45 of PMLA provides that, notwithstanding anything contained in CRPC, no person accused of an offense under PMLA shall be released on bail on his own bond unless the court is satisfied about the twin conditions. And those twin conditions are: there are reasonable grounds for believing that he is not guilty of such offense. Thus, see, at the stage of bail, it has to be recorded that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. The said Section 45, as prior to 2018 amendment, imposing these twin conditions for release on bail, was held to be unconstitutional by the Supreme Court in Nikesh Tarachand Shah. The said Section 45 was amended by the Parliament in the year 2018. In the case of Vijay Chaudhary, the Supreme Court upheld the constitutional validity of Section 45 of PMLA as applicable post-amendment of the year 2018. Although Vijay Chaudhary is under reconsideration, it has been held in Vijay Chaudhary case that the twin conditions as provided under Section 45 of PMLA cannot be said to be an absolute restraint for granting bail. The discretion vests in the court, which is not arbitrary or irrational, but is judicial and guided by the principles of law as provided under Section 45 of PMLA. It has been held that the court, while dealing with the application for grant of bail, need not delve deep into the merits of the case, and only a view of the court based on available material on record is required. The court will not weigh the evidence to find the guilt of the accused, which is of course within the purview of the trial court. The court is only required to place its view based on probability on the basis of unreasonable material, on the basis of reasonable material collected during investigation. And the said view will not be taken into consideration by the trial court in recording its findings of the guilt or acquittal during trial, which is based on the evidence adduced during trial. Reasonable ground for believing means the court has to see only if there is a genuine case against the accused and the prosecution is not required to prove the charge beyond all reasonable doubt. However, what is significant to note that in Vijay Chaudhary, it has been specifically held that the beneficial provision of Section 436A of the CRPC could be invoked by the accused arrested for an offense punishable under PMLA. It is well established that speedy trial is one of the facets of right to life and liberty guaranteed under Article 21 of the Constitution of India. Speedy trial is an essential ingredient of reasonable, fair, and just procedure guaranteed by Article 21, and it is the constitutional obligation of the state to devise such a procedure as would ensure speedy trial to the accused. Section 436A of CRPC came into effect with effect from 23rd June 2006, providing for a remedy to under trial prisoners where a person has undergone one half of the maximum period of imprisonment prescribed for the offense under that law. He shall be released on bail. In Vijay Chowdhury, it has been held that Section 436A of CRPC has been inserted after the enactment of the PMLA in the year 2002, and therefore the said benefit is available to an accused arrested under PMLA. The provisions of PMLA are subject to the interpretation in various judicial decisions, and they will continue to remain a subject of judicial interpretations as the implementation of PMLA also raises concerns regarding liberty. As a legal position concerning the Prevention of Money Laundering Act is still evolving, I hope and trust that Mr. Dubey, the author of this commentary, will be required to publish a supplementary book very soon, and all of us will be invited for that function also. Of course, this doesn't mean that Chief Justice should continue this as my assignment. I once again congratulate Mr. Dubey for writing a very useful commentary on PMLA. Thank you for inviting me to this book launch. Thank you.
Thank you, sir, for your enlightening words on bail. Section 45, among various issues, has indeed been a topic of intense discussion these days. And we hope that with your justice guidance, Mr. Dubey would indeed be asked to write another book. I would break from the sequence of events since sir had mentioned that the learned AG has been silenced. So I would jump the queue and break the sequence in inviting him first. Our invitee is... So I would then request him to break his silence from the podium. Just a few words about Honorable Dr. Virender Saraf, who's the Advocate General of Maharashtra. Mr. Saraf did his graduation from Guwahati. He completed his LLB from Government Law College, Bombay, and later did his PhD on the topic Judicial Intervention in Arbitration in India. Dr. Saraf has been practicing in Bombay High Court for nearly 25 years. He also served as an honorary secretary of the Bombay Bar Association, the oldest association of lawyers practicing in the Bombay High Court. Dr. Saraf was also part of chambers of now Chief Justice of India, Dr. D.Y. Chandrachud. He's also appeared in several cases of public importance in high-stake arbitrations, public sector units, and statutory bodies, and also acted as arbitrator, mediator, and conciliator. And there are several reported judgments to his hat. Dr. Saraf was designated as a senior advocate in February 2020, and thereafter came to be appointed as Advocate General of the State of Maharashtra in December 2020. Sir, I would request you to kindly say a few words.
Thank you very much. Honorable Justice Ujjal Bhuyan, our Honorable Chief Justice, Justice Karnik, Justice Jamdar, Justice Patil, Mr. Upadhye, my fellow lawyers and ladies and gentlemen. I was told very early in life that when wise men are speaking, you stay quiet. And that is what I had chosen to do today. And all my lawyer friends will know that once a judge has formulated any proposition, a wise lawyer always says, I couldn't have formulated better than this, my lord. So after Justice Jamdar has set out everything about the law, I'll only say that I could have never formulated it better, and therefore I chose to remain quiet today. I'll not take much of your time. Thank you very much for giving me this opportunity. It is very important, I've always realized, that a lawyer keeps his academic side alive. Because, as Justice Jamdar said, a student of law includes a lawyer, a senior lawyer, and a judge, and a law is always a process of learning. And reading it with an academic interest always enriches a lawyer and gives him a view which otherwise he would never have. When we get a matter, we take up that matter, we read the facts, and we try to apply the provision which is applicable in that case. But reading a statute or a law academically to tracing its origin, seeing what led to this legislation or any law, that gives us an overall perspective of why this law was enacted, what is the purpose of its provisions, and where it falls short. And there, I feel that a perspective of a lawyer as against a pure academician becomes different, because a lawyer has a much more practical view of the subject, because he's not just reading the bare text of the law, but he is seeing it unfold in court. He's seeing every day what is the effect of the law, how the judges are reacting to provisions of that law, and every aspect of that law being implemented, the follies of that law, where it falls short, where it is abused, everything a lawyer is cognizant of. And therefore, a lawyer's perspective on an analysis of the entire law from an academic angle is really a very important perspective. And I'll congratulate Mr. Dubey for undertaking this. I'm sure this book will be of immense help to every lawyer. And I hope more and more lawyers spare time from the extremely busy schedule like Mr. Dubey has done to come out with more and more books and articles on different subjects, which will leave lawyers enriched and also provide guidance to the newer generation of lawyers, also encourage them not to use law only as a means of earning money, but also to understand the social ramifications of the law and the impact that the law has on the society at large. Because as lawyers, our role is not only to go and argue cases, but to make sure that the law unfolds in a manner that subserves the common good. So once again, I would congratulate Mr. Dubey, and thank you very much for giving me this opportunity again to speak. This is, I realize, a breach of protocol. I've, after taking over as AG, understood the meaning of protocol, and I understand that I being asked to speak in between is a complete breach of protocol. My apologies for that, and I'm grateful once again. Thank you very much.
Our next guest is Honorable Mr. Justice Makrand Karnik. Justice Karnik completed his LLB from Pune University, securing first class with distinction. He started his practice at Bombay High Court and has appeared in a number of civil, criminal, labor, service, and constitutional matters. He was elevated as additional judge on today, in fact. It's in fact his 8th anniversary, sorry if I'm correct in my calculation. Justice Karnik has made a distinguished contribution to the field of law. His notable judgments reflect his deep understanding of the law and commitment to justice. His judgments are a testament to his profound humanity, as evidenced by his compassionate decisions to grant bail to individuals who have been confined for an extensive period. His emphatic approach to justice is truly commendable and serves as a beacon of hope for many. His rulings not only uphold the law, but also underscore the importance of compassion in the pursuit of justice. Justice Karnik has also penned many judgments on the law of PMLA and has in fact written a very informative introduction to this book, for which all of us are very indebted to him. I request Justice Karnik to say a few words.
Honorable His Lordship Justice Ujjal Bhuyan, Honorable my Chief Justice Shri Upadhye, my dear colleague Mr. Justice Madhav Jamdar, my other distinguished colleague Mr. Justice Rajesh Patil, the Advocate General Mr. Virendra Saraf, the author of the book Shri Akhilesh Dubey, my seniors who are present here, all the senior counsels, Bhuyan Bhabiji, all my dear advocate friends, Patil Bhabiji. Well, after my dear friend Madhav Jamdar says something, it is impossible to cover up. And yes, I must say that unfortunately for him maybe, we have been friends for the past 30 years. And I really don't know why we are good friends. Because there's nothing common in between the two of us. He has many good qualities and I have not so many good qualities. And the one hint that he gave, I guess the Chief Justice was very pleased. And he whispered into the ears which I could hear over here, that इनके कई राज Justice Jamdar को मालूम है. I am a little shaken up today. But yes, sometimes opposites do attract. And that is how me and Justice Madhav Jamdar have been. Well, I have been trying to tell him the good virtues of not so good qualities in life, and he has been trying to tell me why one must inculcate good qualities. But anyway, the fight is on, the struggle for both of us is on, it will go on. Well, yesterday we had a cricket match, and well, we lost, and we lost quite badly. The Advocate General, as usual, bowled a very good spell. He left everybody spellbound today. That is how his spell was. And today in the morning, he said, well, we were not very happy with the lawyers winning. But in the morning, he rubbed it in and said that tomorrow you can always say, since we are tired, age has caught up with us. He said, tomorrow you can tell the lawyers, I am pained to say this, I am pained to say that, because the body is really aching. Now, about the book, Mr. Akhilesh Dubey ji has really utilized the period during COVID to the best of his advantage, written such a wonderful book, a comprehensive treatise on PMLA, a burning topic. Well, my grievance against him is he should have met me earlier to tell me he's writing a book. Because during COVID times, I was fascinated with two things. One is I learned some cooking, and I learnt cricket. That is how I utilized my time. I wish I had utilized my time for some academic pursuits. But when he came to me and said, you write an introduction for this book of PMLA, well, I was a little, and I didn't know what to say because the foreword was to be written by His Lordship Justice Gawai, whom we all respect, whom we all know. And writing a foreword written by him, an introduction written by me was a little terrifying for me. But nevertheless, I had to go on with the job. I didn't lose this opportunity. I'm really thankful to him. You may wonder whether I'll be speaking on the contents of the book. But in Marathi, there is always a saying. Those who are Maharashtrians will know the importance of these words. Zakli mut sawa lakhachi. Well, I heard just last month, Rui Rodriguez was there. He had organized one doctors' conference of the surgeons. And fortunately for me, just before the conference, His Lordship Justice Bhuyan said, if you could go through my notes. And he gave his note to me, his preparation to me. I went through that. And then I decided, whenever Justice Bhuyan is with me, I'm never going to talk about substance. And then, on two occasions at least, I heard the Lordship, the Chief Justice, speak on constitutional law. One was at Uttan, and the other one was at Nasik. His Lordship's grip over the Constitution is so much phenomenal. It's a pleasure hearing him talk on the Constitution, on the constitutional principles. So today with the two speakers who are coming after me, I don't think I should come in the way between these two speakers, erudite speakers, and you. I can only compliment Mr. Akhilesh Dubey that he has given a wonderful gift to all of us, which we should cherish, we should read, and I wish him all the best. Thank you so much.
Thank you, Justice Karnik, for your jovial comments and interesting anecdotes. Our guest of honor is Honorable the Chief Justice Devendra Kumar Upadhye. Justice Devendra Kumar Upadhye is the 47th Chief Justice of the Bombay High Court. He is a highly respected figure in the judiciary. As a lawyer, Justice Upadhye has specialized in civil and constitutional law. His commitment to justice and his profound understanding of the law led to his appointment as the Chief Justice of the Bombay High Court on 24 July 23. His tenure has been marked by his dedication to upholding the principles of justice and his unwavering commitment to the rule of law. Justice Upadhye's notable judgments include a landmark ruling that HIV-positive patients cannot be denied employment or promotion, emphasizing the importance of equality and non-discrimination. In his illustrious career as a judge, Justice Upadhye has always stood for what is right and what is not acceptable. He passed a judgment so that a married daughter can also apply for compassionate appointment in the state government jobs. He has been passing judgments and orders to protect the city of Bombay from pollution. We are absolutely delighted and deeply appreciative that he's taken time out of his hectic schedule to join us on this platform for today's event. I request Honorable Justice Upadhye to say a few words to grace this occasion. Sir.
Namaskar and a very good morning to all of you. Honorable Shri Justice Ujjal Bhuyan, Judge, Supreme Court of India. Mrs. Bhuyan, thank you, ma'am, for being with us. Justice Makrand Karnik, Justice Jamdar, my esteemed brother Justice Patil, the Advocate General, author of the book, Mr. Akhilesh Dubey. Senior advocates, I can see Mr. Thakkar present here, other senior advocates, other members of the bar, ladies and gentlemen. At the very outset, let me express my sincere gratitude and appreciation for inviting me to this auspicious occasion. I would have been satisfied with simply gracing the occasion with my presence, but Mr. Akhilesh Dubey, however, in his wisdom, decided to ask me to say a few words. The honor and privilege are not lost to me. I am thankful to Mr. Dubey for inviting me as guest of honor this morning. Perhaps a good starting point for my address is with the author himself. This is important because it would give us an opportunity to appreciate why the author ventured into writing a book on Prevention of Money Laundering Act 2002, and why I personally believe that there could not have been a more qualified person to write such a book. With exposure and cognate experience, you will agree with me that the author is in a vantage position to write a book on PMLA. I wish to commend the author for his vision and efforts to document what I consider a very comprehensive account of the operations of the province of PMLA. The Prevention of Money Laundering Act is a significant law, as you all know, passed by the Indian Parliament with the aim of curbing money laundering and seizing assets obtained through such activities. The PMLA was implemented on 1st July 2005 with the main goal of deterring money laundering, allowing for seizure of assets linked to or involved in money laundering, and penalizing those who commit money laundering offenses. Since its inception, PMLA has undergone several amendments. In 2005, 2009, then 2012, and recently in 2019. These revisions in the Act have introduced new concepts and modified existing provisions. For example, 2019 amendment introduced the notion of reporting entity, which encompasses banking companies, financial institutions, intermediaries, and so on. This amendment also eliminated the maximum fine that could be imposed under PMLA. It allowed for provisional attachment and confiscation of property belonging to anyone involved in such activities. Furthermore, the Act's scope and reach have been expanded by refining the definition of money laundering offences in the Finance Act of 2019, making it more stringent by including indirect attempts to engage in activities such as concealing, possessing, acquiring, using, projecting, or even claiming proceeds of crime as unattained property as a punishable offense under the Act. While these amendments have sought to bolster the PMLA and make it more effective in combating money laundering, some argue that they have also complicated the subject. And the most talked about provision, the ambiguity surrounding the twin conditions under Section 45 has sparked a variety of opinions amongst legal practitioners and judiciary. The Supreme Court, as discussed by Brother Jamdar, in the case of Nikesh Tarachand Shah, ruled that Section 45 of Prevention of Money Laundering Act, insofar as it imposes twin conditions for release on bail, is unconstitutional, and it infringes Article 14 and 21 of the Constitution of India. However, after that amendment, later in Vijay Mandalal Chaudhary, Nikesh Tarachand Shah has been overruled so far as it relates to the twin conditions of bail. Likewise, legislature introduced numerous changes in PMLA provisions relating to attachment, investigations, arrest, bail, which were implemented by courts across India. Introduction of new concepts and changes to existing provisions necessitates that legal professionals and others continually update their knowledge and understanding of PMLA. And here lies the need of the book. There are very few sources and commentaries available regarding the provisions of PMLA. Even government websites have not uploaded changes in rules and have only uploaded published gadgets on their websites. This book gathers all information related to case laws, rules, notifications, and legal concepts in one place to aid legal professionals. It offers a thorough overview of PMLA and its amendments over time, as well as a discussion of key cases and their impact on the interpretation and application of PMLA. This book is an essential resource for legal professionals looking to deepen their understanding of PMLA. The official launch of a book is always a proud moment for its author. When I was approached by the author to be the guest of honor in today's function and to deliver an address at the book launch, I did not hesitate in accepting the invitation for two reasons. First is my attachment to the issue that relate to Prevention of Money Laundering Act, and second is my very association with the author of the book. I seek permission of the chair to say a few words in Hindi, please. I run the risk of being misunderstood, but I request all present here not to misunderstand me. दुबे जी हमारे अंचल के हैं, हमारे बिल्कुल पड़ोसी हैं गांव के, और जब पहली बार हमसे मिले तो मैं अपनी भावनाओं को मुझे उस समय जो भी भावनाएं मेरे अंदर उपजी उसको व्यक्त करने का कोई अवसर मुझे अभी तक नहीं मिला। देखिए, बंबई सपनों का शहर, साथ साथ अवसरों का भी शहर। इट इज अ सिटी ऑफ ड्रीम्स एज ऑल्सो द सिटी ऑफ अपॉर्चुनिटीज। दुबे जी की तीसरी पीढ़ी यहाँ माइग्रेट होकर शायद आई थी, इफ आई एम नॉट रॉन्ग, एंड जस्ट सी दिस author, by dint of a sheer, hard work, was able to pursue his studies abroad. He's a solicitor in UK. And I felt very good. अभी सुबह के संबोधन में किसी ने कुछ बोला विद्या धनम सर्व धनम प्रधानम, तो मैं उम्मीद करता हूं दुबे जी से कि जो ज्ञान इन्होंने अर्जित किया है उसका उपयोग आगे भी करते रहेंगे, क्योंकि जैसे ये कहा जाता है खास करके ग्रीक लिटरेचर में कि we sometimes need philosopher kings. So this is the time we need academic lawyers as well. देखिए विद्या की प्रकृति क्या है, ये निर्भर करता है कि जिस व्यक्ति के पास विद्या है उसका वो क्या उपयोग करता है। एक श्लोक है संस्कृत में, विद्या विवादाय धनम मदाय शक्ति परेशान परिपीड़नाय। मैंने जो दुष्ट प्रकृति का व्यक्ति है उसके लिए विद्या विवाद का अस्त्र है। विद्या विवादाय धनम मदाय, धन जो है वो उसके लिए मद का अस्त्र है। मद माने प्राउड, नॉट इन दैट पॉजिटिव सेंस। विद्या विवादाय धनम मदाय शक्ति परेशान परिपीड़नाय। जो शक्ति है, जो बल है उसके पास, वो दूसरों को परेशान करने के लिए। पर साधोर बुद्धि, साधु की जो बुद्धि है, साधु मीन्स अ गुड पर्सन, अ गुड ह्यूमन बीइंग। साधोर बुद्धि विपरीत में तत्, इसके विपरीत होती है। ज्ञानाय, विद्या ज्ञान के लिए, दानाय धन दान के लिए, च रक्षण है, और जो शक्ति है वो दूसरे की रक्षा के लिए है। तो ऐसी उम्मीद के साथ मैं अपनी बात समाप्त करूंगा कि दुबे जी आगे भी अपनी इस विद्या का उपयोग ज्ञान बांटने में, सभी को जो भी जुड़ा हुआ है इस पेशे से, इस जुडिशियल फ्रेटर्निटी के जो भी लोग हैं, उनको इसी तरीके से अपनी दूसरे एकेडमिक एंडेवर्स से हमेशा सबका पथ प्रदर्शित करते रहेंगे। इसी शुभकामना के साथ मैं अपनी बात समाप्त करता हूँ। एंड आई रियली फील गुड व्हाइल आई मेट मिस्टर दुबे एंड केम टू नो द काइंड ऑफ achievements he has to his fort. I mean, it's really makes you feel, and I may tell you, Dubey ji is more Mumbaiker than any other Mumbaiker. So that's the quality he has attained and achieved with the blend of academic pursuits. I hope this will not be the last book. It is only the first in the series, and we hope and expect and wish that many such books are in the offing. Thank you very much.
Thank you, Justice Upadhye, for your very kind and warm words on the book as well as the author. Now it's my absolute privilege to invite the chief guest of today's afternoon, Honorable Justice Shri Ujjal Bhuyan. Justice Bhuyan is a distinguished judge of the Supreme Court. He practiced as a lawyer for about 2 decades, which was petitioner-centric in Justice Lordship's words, as well as for the government. In 2011, Justice Bhuyan was appointed as a judge of the Guwahati High Court. He thereafter graced the Bombay High Court, as well as Chief Justice of Telangana High Court. He was elevated as a judge of the Supreme Court in July 2023. Justice Bhuyan has carved an illustrious path in the field of law and justice. Through his judgments, he's always protected the right to life and liberty enshrined in Constitution of India. He's demonstrated his expertise in various fields of law, including tax as well as PMLA. 2 of the judgments which I would want to mention. In one pick ports, Justice Bhuyan held that interpretation of Section 5 and 8 of the PMLA on the issue of reasons to believe they should be recorded before attaching a property, and reasons should have a direct nexus with the material. In another judgment of 2022 from Telangana High Court, he held that trial of scheduled offense and predicate offense should be carried out by the special court. The humanitarian side of Justice Bhuyan is seen in the case of V. Santa Mogli versus State of Telangana, where the bench led by him declared Telangana Eunuchs Act unconstitutional as it violated the human right, privacy and dignity of LGBT community, infringing on Articles 14 and 21 of the Constitution. The liberal approach excludes from his judgment in Arnab Goswami versus State of Maharashtra, where he observed, and I quote, 70 years into our republic, we cannot be seen to be skating on thin ice, so much so that mere mention of a place of worship will lead to animosity or hatred among religious communities, causing upheaval and conflagration on the streets. With his vast experience, knowledge, and commitment to justice, we hope he continues to aspire and uphold the values of Indian judiciary. Last but not the least, he also loves music and acting and follows sporting activities. We express gratitude and thank him to grace the stage during his busy schedule. Sir, kindly say a few words to grace the occasion.
Justice Devendra Kumar Upadhye, the Chief Justice of the High Court of Bombay, my former distinguished colleagues of the Bombay High Court, Justices Makrand, Karnik, Madhav, Jamdar, with whom I shared the bench for almost 6 months, and I think we did some good work there. And Justice Rajesh, Patil, all judges of the Bombay High Court, my dear friend, Learned Advocate General for the State of Maharashtra, Dr. Birendra Saraf. We have many things in common. Star of today's program, the learned author, advocate and solicitor, Akhilesh Dubey. Publishers, Bharat Law House Private Limited. Eminent senior advocates, members of the bar, Sanghamitra and Mrs. Patil. Distinguished guests, ladies and gentlemen, a very good morning to you all. It's 11:45. It happens with me most of the time. Though my schedule is always in the forenoon session, by the time my turn comes, it is post-noon. So always I have to change from good morning to good afternoon. Luckily today it's still in the morning hours. I'm very happy here to be present here this morning. To be part of this book release function of the book Treatise on PMLA, Law and Practice, authored by Sri Dubey and published in 2 volumes by the publisher, Bharat Law House. PMLA, that's Prevention of Money Laundering Act 2002, is the most contemporary subject in recent times. Law on the subject is evolving, and therefore the need for legal literature. The 2-volume book is a labor of love of the learned author, who has taken great pains in researching through various provisions of PMLA and the related case laws. I compliment him for writing this book, which I am sure will be very useful not only to the bar, but to the bench as well, and also for officials of the Enforcement Directorate who have been given the task of implementing the provisions of PMLA. I thank all those who helped Sri Dubey in this highly creative endeavor of his. Dubey has suffered some personal setback, but he has successfully overcome this, and this is the achievement of his hard work. I therefore compliment him. Well, Mr. Dubey, the story of everybody may not be similar, but the life is very uncertain. It's not even. People face difficulties in life. People face setbacks in life. But how you overcome that, how you face the challenges, that is the true test of a person's character. So in this, I think the author has come out with flying colors. Thank you. Congratulations. I also take this opportunity
to compliment the publishers, Bharat Law House, for publishing the book. Friends, as in movies, where we have behind the scene or behind the camera, various players whose contribution to the making of a film cannot be understated. Similarly, the role of law book publishers in the legal field cannot be ignored. Be it the profession, be it the courts, or be it the academia, law books and by extension law book publishers play a significant role. They are a vital clog in the administration of justice. Despite advancement in technology, law books are here to stay. One cannot think of a lawyer's chamber without books. Therefore, we must acknowledge the role of law book publishers in the life of law and justice. The field of law and justice would be incomplete without the silent contribution of the law book publishers. My congratulations to Bharat Law House for publishing the book, that too, in 2 volumes. Regarding writing a book, Brother Patil has said something. I wish and I pray that he completes the assignment and brings out the book on Hindu law, which will be of great help to the practitioners of Hindu law. Well, writing a book and choosing a topic, I remember a discussion I had, or a talk I had with my then Chief Justice, Justice Ajit Singh. He was my Chief Justice. He is the son of that legendary G.P. Singh. So he was telling me about his father. He said that his father was initially inclined to write a book on Constitution of India. Later on, he realized that already the field was covered, as we say in law, occupied field. So he found that D.D. Basu's commentary was there, and so many. So after some thinking, he decided that he will write on interpretation of statutes. So G.P. Singh's statutory interpretation of this statutes is now a legend, actually. This is the book par excellence on the subject. I pray and I hope that Dubey's book on PMLA will also achieve the stature of Justice G.P. Singh's book on interpretation of statutes. Justice Gawai, Judge Supreme Court of India, and he's our senior, esteemed senior, and our guide, friend, philosopher, and guide. He has written a very inspiring foreword. Justice Makrand has also penned a very detailed and analytical introduction. This is an acknowledgement of and tribute to the hard work and competence of the learned author. Well, friends, before I say something, I must put in a caveat. As I said, PMLA is a live issue. And to put it, it's a hot issue, like a hot potato. Cases under the PMLA are hotly contested. And for whatever reasons, many of such cases have acquired political overtones. Being a sitting judge of the Supreme Court, matters arising out of PMLA are regularly listed before my bench. Therefore, I will only confine myself to the text of the law and a few of the decided cases. Well, Justice Jamdar has referred to money laundering, the Black's Law Dictionary. It says, money laundering is the act of transferring illegally obtained money through legitimate people or accounts so that its original source cannot be traced. In the United States, it's a federal crime. Justice Karnik has explained money laundering in simple terms. Just as laundering refers to cleaning clothes, money laundering involves cleaning money obtained through illegal activities by using it for legitimate purposes. It's a complicated offense, no doubt about it. it is not only multi-layered, but it is also a continuing offense. Adding to the complexity, many PMLA cases have got transnational ramifications as well. Essence of money laundering is introducing crime-tainted money, which is textually referred to as proceeds of crime, into the regular economy, and in the process, make such money appear as legitimate. The author has delved into this aspect and has noted that there are 3 stages in the process of money laundering. The first stage is placement. In this stage, the illegally acquired dirty money, we call it that way, dirty money, or the proceeds of crime, are moved from its original source into the legitimate financial system. In other words, money acquired through criminal activities is successfully introduced into the legitimate financial system. Next comes the layering stage. In this phase, the proceeds of crime are concealed or disguised. Such proceeds may be invested in respectable business ventures. At this stage, services of shell companies may be utilized. Money accruing out of such investments would therefore appear to be earned legitimately. The final stage of money laundering is integration. It is the stage where proceeds of crime are reintegrated into the legitimate financial system and mixed with other assets acquired through legitimate sources of income. Thus, the trace of the crime money gets obfuscated or erased completely. As I said, there is an international dimension to money laundering. One of the concerns of different countries related to laundering of proceeds of crime arising out of illicit traffic in narcotic drugs and psychotropic substances. It was observed that such type of money laundering posed a serious threat not only to the financial systems of the countries, but also to their integrity and sovereignty. Therefore, a convention was held in December 1988. It's called the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances. It is also known as the Vienna UN Drug Convention. And a treaty was signed thereafter by 43 countries. This convention not only declared money laundering as an offense, but also made aiding and abetting of money laundering as an offense. A financial action task force was also formed in the summit of 7 major industrial nations, G7 as we say. And the focus of this task force, and it continues to be so, is to tackle the menace of money laundering. Friends, money laundering is no longer associated with drugs. Though internationally, it still poses the major threat. It is now associated with all kinds of illegal activities and crimes, both transnational and domestic. If I take a digression for a moment, if you look at the international crime scenario, the broad international crime scenario, drugs and narcotics is now no longer the numero uno, as you can put it this way, in the world of crime. Maybe because of the stiff penalties imposed in many of the countries, particularly in the Southeast Asia. It is now being replaced by crimes relating to wildlife crimes, crimes relating to human trafficking, crimes relating to guns and weapons. So these are the 4 major areas of worldwide crime having transnational ramification. So it's not only now drugs, the net has become that much more wider. There are various other international developments relating to money laundering, such as successive reports of the Financial Action Task Force, the Strasbourg Convention, the Basel Committee principles, so on and so forth. For paucity of time, we will not go into that. Suffice it to say that the United Nations General Assembly held a special session, and in that, a resolution was adopted calling upon the member states to adopt national money laundering legislations and programs. To implement the above political declaration, the Indian Parliament enacted the Prevention of Money Laundering Act 2002, that is the PMLA, which came into force on 1/7/2005. PMLA has undergone several amendments since 2002. Some of the amendments are under challenge before a larger bench of the Supreme Court. I think the case is Roger Matthews, subject to correction. On various grounds, these amendments have been challenged, but primarily the ground is that amendments to PMLA could not have been enacted by the Parliament by way of a Finance Act. Since the issue is sub judice, I would refrain from making any comment thereon, because this is a very live issue. Sooner or later, this issue will have to be decided one way or the other. Friends, if you look at the scheme of the PMLA, it can broadly be divided into two parts. The first part relates to civil consequences, and the second part deals with arrest and criminal prosecution. Be it provisions relating to attachment of property or provisions relating to search and seizure, arrest, etc. The sine qua non for setting the provisions of PMLA in motion is the reason to believe of the authorized officer that the concerned person is involved in the offense of money laundering and is in possession of any proceeds of crime. The offense of money laundering is provided in section 3, that's the offense defining section, and the punishment is provided in section 4. So without entering into specifics, we can broadly say that a person would be guilty of committing the offense of money laundering if he is involved in any process or activity connected with the proceeds of crime and projecting it as untainted property. Now, proceeds of crime, as per the definition clause, it means any property derived or obtained by any person as a result of criminal activity relating to or relatable to a scheduled offense, an offense which is there in the schedule. The offenses mentioned in the schedule includes offenses under the IPC, under the UAPA, under the NDPS, under the Wildlife Protection Act, so on and so forth. Such proceeds of crime would also include any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. Simply put, to constitute the offense of money laundering, number one, there must be proceeds of crime derived from or obtained as a result of criminal activity relating to or relatable to a scheduled offense. So therefore, the second requirement is that there must be a scheduled offense. Then there must be proceeds of crime derived from or obtained as a result of criminal activity relating to or relatable to a scheduled offense. Finally, the person concerned must be involved in any process or activity to project the proceeds of crime as untainted property. It is only on fulfillment of these above three conditions, ingredients, that the offense of money laundering is committed. While I was in Telangana, in one case, Vijay Sai Reddy versus Enforcement Directorate, I have said that the expression proceeds of crime, which is the very essence of the offense of money laundering, needs to be construed strictly. Only such property which is derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense can only be regarded as proceeds of crime. In another case, my bench in Manturi Shashi Kumar versus Directorate of Enforcement, it held that authorities cannot resort to any action against a person under PMLA for money laundering on an assumption that the property recovered by them must be proceeds of crime and that a scheduled offense has been committed unless the offense is registered with the jurisdictional police or is pending inquiry. Now the punishment, as I said, is in 4. It's not less than 3 years, but which may extend to 7 years, and with fine. Initially there was a cap of 5 lakhs, now that cap has been omitted. If the proper officer has reason to believe that any person is in possession of any proceeds of crime which is likely to be concealed or transferred so as to frustrate proceedings under the PMLA, then under Section 5, he may provisionally attach such property for a period not exceeding 180 days. Again, such provisional attachment is subject to confirmation by the adjudicating authority under Section 8. Crucial expression here is reason to believe, both at the stage of provisional attachment under 5 and during confirmation proceedings before the adjudicating authority under 8. It will not be enough only to say that there was reason to believe at the stage of 5. The reason to believe in 8 must be different. This interplay between this expression occurring in 5 and 8, I have explained in one of my judgments. I am not going to repeat this. Now, this expression reason to believe is a crucial one, but it is not defined in PMLA. It's not a defined expression. But this expression, reasons to believe, finds place in several taxing and penal statutes, notably in the Income Tax Act. And this expression has received considerable judicial attention. Way back in 1960, in the context of reopening assessment under the old Indian Income Tax Act 1922, Supreme Court in the famous case of Calcutta Discount Company held that the income tax officer must have reason to believe that income had escaped assessment, income chargeable to tax had escaped assessment before he could proceed to reopen a concluded assessment. There must be a live link between the reasons recorded, which again must be on the basis of materials gathered, and the formation of belief that income chargeable to tax had escaped assessment. Then only he gets the jurisdiction to reopen an assessment. Such reason to believe must therefore be germane to the issue and should not be fanciful. Reason to believe cannot be equated with reason to suspect. The power to arrest is provided in Section 19. Here also the arresting authority must have reason to believe on the basis of material in his possession that such and such person is guilty of the offense of money laundering. In that case, he may arrest such person and inform him of the grounds of arrest. We'll deal with this a little bit later. Contrary to the presumption of innocence of the accused in regular criminal proceedings, there is a reversal of the burden of proof in Section 24. The presumption is that the person charged with the offense of money laundering is involved in money laundering. That is the presumption, that is the legal presumption. And that the proceeds of crime are involved in money laundering. Of course, this is a rebuttable presumption, but the contrary can be proved only during the trial, not at the stage where you are dealing with the bail. Though officers of Enforcement Directorate are not police officers, and therefore the bar of Section 25 of the Indian Evidence Act 25 says that no statement made before the police would be admissible in evidence. So this bar, because officers of Enforcement Directorate are not police officers, would not be applicable to them. Nonetheless, in a case arising out of the Foreign Exchange Regulation Act 1973, there also the implementing agency is the Enforcement Directorate. The Supreme Court in A. Tajuddin versus Union of India has sounded a note of caution that statements made to officers of the Enforcement Directorate ought not to be readily believed unless there is independent corroboration. Of course, that was in the context of a retracted confession. Supreme Court said that such statements can be easily thrust upon the person either summoned or facing investigation. Now, then comes the most talked about provision, Section 45, which is the provision for bail. There are two additional limitations. In addition to the normal limitations under the CRPC, we have two other additional limitations. In fact, to understand the rigor of this section, it needs to be pointed out that this section starts with a non-obstante clause, notwithstanding anything in CRPC. It starts with a non-obstante clause, and the entire section is negatively worded. No person shall be released on bail. So the section itself is couched in negative language. The two additional conditions, also referred to as twin conditions, are that number one, the public prosecutor should be given an opportunity to oppose the bail application. Number one, there's no difficulty there. Number two, if the public prosecutor opposes the bail application, then the court must, the burden shifts to the court must record its satisfaction that the accused is not guilty of the offense of money laundering and that he is not likely to commit any offense while on bail. We'll deal with this aspect also. Power of issuing summons for production of documents and to give evidence is provided in Section 50. Such power is akin to the powers vested in a civil court while trying a suit under the Civil Procedure Code, and is to be exercised in respect of discovery and inspection, enforcement of attendance of any person, examining him on oath, etc. As was pointed out earlier, a two-judge bench of the Supreme Court examined the validity of Section 45 in this case of Nikesh Tarachand Shah versus Union of India. The bench of Justice Rohington Nariman and Justice Sanjay Kishan Kaul examined the said provision which imposed the twin conditions of grant of bail. At that time, it was provided that the offense punishable for a term of imprisonment of more than 3 years under Part A of the schedule. The bench referred to the object of bail as set out in Gurbakh Singh Sibia's case, the Constitution Bench judgment, and quoted Justice Krishna Iyer, and I quote, "The issue of bail is one of liberty, justice, public safety, and burden of the public treasury, all of which insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process." Supreme Court referred to Article 21 as the Ark of the Covenant so far as fundamental rights are concerned. Though our Constitution has no due process clause or the 8th Amendment as in the US, but when it comes to the question of right to life and personal liberty of the citizens of India, following the law laid down by the Supreme Court in Cooper's case and Menka Gandhi's case, the consequence is one and the same. So therefore, following on this, in Nikesh Tarachand Shah, the two-judge bench declared Section 45(1) of PMLA insofar as it imposed two additional twin conditions for release on bail as unconstitutional, as it violated 14 and 21, Articles 14 and 21 of the Constitution. This is a judgment of 2018. 2 years later, a three-judge bench of the Supreme Court in Vijay Madan Lal Chaudhary reversed it. The three-judge bench dealt with various challenges to different provisions of PMLA, including the amendment of 2018, whereby Parliament amended Section 45 after the decision in Nikesh Tarachand Shah, removing the defect and reviving the twin conditions. The three-judge bench upheld the amendment, which came into effect from 19/4/2018, and thereafter declared Section 45 as reasonable and constitutional. In fact, all the challenged provisions of PMLA were declared constitutionally valid. Friends, Vijay Madan Lal Chaudhary is now under consideration of the Supreme Court as to whether it should be referred to a larger bench. So again, it would not be proper and prudent to discuss and dilate too much on Vijay Madan Lal Chaudhary. In Senthil Balaji, in this case, again a two-judge bench of the Supreme Court held that this is regarding arrest. The authorized officer, while arresting a person, must perform the mandatory duty of recording reasons, and this should be followed by serving the information of the grounds of arrest on the arrestee. But the bench stopped at that and did not elaborate further as to how the information should be served upon the arrestee. The question as to how Enforcement Directorate is required to inform the arrested person of the grounds of arrest has been undecided by a two-judge bench of the Supreme Court in Pankaj Bansal. The bench noted that no consistent and uniform practice was being followed by the Enforcement Directorate in the country. In certain parts, written copies of the grounds of arrest were furnished to the arrested persons, but in other areas, such practice was not followed. The grounds of arrest were either read out to the arrested persons or allowed to be read by them. So, to give a true meaning and purpose to Section 19(1) of PMLA, the bench in Pankaj Bansal held that henceforth a copy of the written grounds of arrest should be furnished to the arrested person as a matter of course and without exception. In all cases, the written grounds of arrest must be furnished to the arrested person. A little later, 2 months later, a coordinate bench of the Supreme Court in a subsequent decision in Ram Kishore Arora took the view that Pankaj Bansal would be prospective, as the word used in the said decision is henceforth. The same need, without getting into specifics, I would say that we need not be detained by this decision, inasmuch as even as per this decision, post the decision in Pankaj Bansal, the authorities of PMLA, Enforcement Directorate, are under a legal obligation to serve upon the arrested person the written grounds of arrest. There is no dispute on that. Only dispute is that this would not be applicable to the arrest made prior to Pankaj Bansal. Well, there can be several views on this. I would not disclose or discuss what is my view. as and when a matter comes up, now we have to coordinate benches' decision, equal strength. I'm sure the wisdom and discretion of the benches hearing matters will guide them how to deal with a matter and adopt that view which is more consistent with our constitutional philosophy as mandated in Article 21. Friends, the law on PMLA is evolving. The last word is yet to be spoken. Therefore, there is enough scope for subsequent editions, including revised editions of this book. And as was pointed out earlier, as and when the revised edition comes or later editions come, I'm sure the publishers and the authors will again invite us and again invite all of you to share our thoughts and views on the PMLA. In the meanwhile, all that we can hope and pray is that the law would be applied judiciously. A number of benches of the Supreme Court, I can recall the bench of Justice Sanjay Kishan Kaul and Justice Sudhanshu Dhulia on one particular occasion, then a bench of Justice Surya Kant and Justice K.V. Vishwanathan on another occasion. They have observed in the course of hearings that there is a need for restraint and transparency. Friends, PMLA is a potent weapon in the fight against crime-tainted money. It is very much necessary to fight the menace of money laundering. But we all know that a weapon loses its potency if it is overexposed or over-applied or even misused. If that happens, there may be a negative perception about the actions of the Enforcement Directorate and by extension PMLA. If this happens, then it is the community and by extension the nation which will suffer. Again, pausing for a moment, it's a well-accepted principle in law that stiffer the procedure, criminal procedure, the higher will be the level of judicial scrutiny. There's nothing wrong in that. The objective is always to ensure that in the process of prosecuting and punishing the guilty, the innocent person should not suffer. If he has suffered, the sufferance should be minimized to the extent possible. That's the object of legal intervention of the constitutional courts. We hope and trust that all the stakeholders will apply the law in its true spirit, having regard to the objective of the legislation and keeping in mind the overarching constitutional mandate of Article 21 of the Constitution of India. My best wishes to the learned author and the publishers. Thank you very much. Thank all of you for sparing this Sunday morning and to be here. And God bless you. Thank you.
Thank you, sir, for your enriching and exhaustive words on various aspects of PMLA. As the PMLA law continues to be a hot topic of discussion in legal circles, we are sure your judicial guidance from apex courts is the need of the hour. Now, before I invite Mr. Dubey, the author of the book, for a vote of thanks for today's afternoon, I request the dignitaries to kindly just hold the book because, as sir said, that in evolving times there's also a need of a photo opportunity. I'm told that a photo has to be taken properly. So,
but we have only 2 books.
We'll just get the additional books, sir. I'll now request Akhilesh Dubey, my good friend, to say a vote of thanks.
Thank you, Amit. Good afternoon to all the honorable dignitaries and the members of the bar present. The Honorable Chief Justice said that the lawyer cannot be silenced. I think the lawyer can be silenced by gratitude, be it in cash or kind. Once there is a gratitude, the lawyer can be silenced. I stand before you all with heart full of gratitude. It is indeed an honor for me and my colleagues who have made this event possible to have the opportunity to express our sincere thanks to the honorable judges, senior advocates and members of the legal fraternity who have graced this occasion with your presence. Thank you, Honorable Justice Bhuyan, for attending this occasion with family on a short notice. Thank you, ma'am, and Shweta for accompanying sir and attending this event. Sir, despite your pressing schedule in Delhi, your esteemed presence here in Mumbai has filled every one of us with a sense of pride and honor. Listening to your profound insights and the wisdom on the law is always an enlightening and enriching experience. Thank you once again for making this event memorable with your presence. Honorable Chief Justice, we extend our heartfelt gratitude to you for gracing this event with your esteemed presence today. Despite your prior commitments, you have bestowed upon us the honor of your time. Your unwavering dedication to law and society serves as a beacon of inspiration to all of us. We are deeply thankful for your guidance and wisdom you impart. Thank you, sir. And sir said about the affection. First day when I went to meet the Honorable Chief Justice, it was advised by my learned senior, Mr. Atul Rajadeksh, that he is from your, जैसे sir ने कहा, अंचल के हैं, so you should go at least and meet him. I went and the meeting I was scheduling or thinking of 5 minutes, sir was kind enough to give me 50 minutes. And as sir said that I'm more Mumbaikar than everybody thinks, it is right because sir knew everything about our place, my place, and everyone. And I was completely unaware of many things which sir has told me on that day. Thank you, sir. And the affection was mutual, sir. Justice Karnik, we are thankful to you for making all this possible. Despite our paths crossing only in corridors of Bombay High Court when you were a lawyer and I was very much a junior, when I went first with the manuscript of the book to Justice Karnik and asked him or requested him to write an introduction, he agreed to write that introduction after reading the manuscript. I'm thankful to you, Justice Karnik. Your willingness to review the manuscript and contribute your thoughts in form of an informative introduction and instilled in lawyers like us a renewed sense of hope and belief that our efforts to contribute to the field of law will be recognized and appreciated. Justice Jamdar, your inspiring thoughts and insights will serve to us as a guiding light in our legal careers. We are deeply grateful for your presence and sharing your wisdom. Justice Patil, your journey, beginning from the humble beginning to the pinnacle of the legal profession, is nothing short of inspirational. Your unwavering commitment and integrity towards the law are virtues that we aspire to emulate. I also know Justice Patil from last 20 years, but unlike Justice Jamdar and Justice Karnik, I don't know anything, any of his secrets. There is nothing. Our sincere... I also express my gratitude to Learned Advocate General who could make it to this event on a very short notice. In fact, all of us will agree that he has been a guiding factor to lawyers like us, and we all try to emulate him with respect. Our sincere gratitude extends to Honorable Justice Mr. B.R. Gavai, who kindly contributed the foreword to this book. Unfortunately, due to other commitments, he was unable to be with us today. We appreciate his contribution to the book and this event. I extend my gratitude to my parents, family, and seniors, Arun Tripathi sir and Meena madam, who have been gracious enough to be present today. And retired Justice Mr. B.H. Maglapalle, who has always stood with me and also my publishers, Bharat, for publishing the book and organizing such a wonderful event. I thank senior members of the bar and my friends who are present today for gracing this event with their presence. Last but not the least, I'm dragging you all on a Sunday. I'm very sorry for that, apart from being thankful. I heard somewhere or read somewhere that Justice Bhuyan still has regrets that he wanted to learn guitar and, and swimming, which he could not. But when Chief Justice was retiring from Allahabad High Court, he had given a lecture, farewell speech, wherein he had said, he has quoted his father, I quote his father, a lawyer has to live like a hermit and work like a horse. We part today with this wisdom, and we continue to strive for the advancement of the law and for the betterment of the society. Once again, we all express our deepest gratitude to all of you for taking your time out of your busy schedules to attend this event. Your support and encouragement are greatly appreciated. I'm sorry I'm not speaking about the subject because already Justice Bhuyan's lecture was so elaborate that nothing was to be added in that. In fact, I'm now thinking why it became 2 volumes. Justice Bhuyan in 20 minutes has explained the entire act. I'm thankful to you and I'm thankful to all the dignitaries. Thank you. Thank you for being present.
Last but not the least, Mr. Ravi Puliani, who is the Managing Director of Bharat Law House, would want to say some words.
I thank Justice Bhuyan, the Chief Guest and Judge Supreme Court of India, the Honorable Chief Guest, Guest of Honor, Justice Devendra Upadhye, Chief Justice of the High Court, and the Honorable Judges and the Advocate General, including the author who are all present here on a Sunday morning, as he said. During the course, I think the cat is already out of the bag. How could Mr. Akhilesh Dubey write 2 volumes on PMLA? The fact is, yes, we received a phone call from him during the COVID to write a book on PMLA, and we signed, and he worked very hard, dedicatedly for more than 2 years to work on the subject. And then the matter was in the court, Vijay Madanlal Chaudhary's case, we had to wait for it. And finally, we have come out with the book. And thank you very much, the entire dignitaries who are present here for, on a Sunday morning, to be with us for the release of the book. Thank you very much.
Thank you everyone for coming. With this, we come to the close of the session. We are requesting all guests to kindly proceed to the experimental theatre lawn for lunch, and our volunteers would be happy to guide you. Thank you.